Welcome to the WN Legal Podcast.
Welcome to WN Legal's next podcast. My name is Amy and I'll be the host of this podcast. Next to me I have Q, who is the business partner of the firm. Now Q deals primarily with criminal law matters, but he does also delve into family law matters. Now today we will be discussing a criminal law topic. We'll chat about that topic in a moment, but firstly we just need to put a short disclaimer in relation to this podcast. Now, the contents of this podcast is just a general discussion about the areas of law that we practice in that the public may be interested in. This podcast should not be taken as a substitute for legal advice whatsoever, as each case is completely different. Now, I'll hand over to Q now, who's going to be talking about the unlawful possession of
Money.
Yes,
thank you, Amy. Thanks. Now, today we'll be talking a bit about unlawful possession charges. The actual name of the charge is possession of unlawfully obtained property. But for the purposes of today's podcast, we'll be talking about money as the charge and people being alleged to possess money that is unlawfully obtained or suspected to be stolen. So the reason why we're talking about this is because in the recent times in our practice, we have been dealing with single charges in itself. One charge, the charge of possession of unlawfully obtained property being money. We're not even talking about property that are suspected to be stolen, like stuff you see on eBay being sold, and then you see a radio, a high quality radio in your house suspected to be stolen and police charging you for that. No, we're talking about possession of money and police charging people with having to keep money at home, obviously a handsome amount. So from experience, somewhere between 20 to all the way to $500,000. There are people out there that keep money at home. It's not irregular. In the olden days, you get a lot of older people keeping money at home. There was actually an article very recently of an old lady. She kept, I think, 20 grand in her old couch, and his grandson sold the couch and sold the 20 grand worth of couch. Well, the contents within the couch in itself, which was the money. But there are people out there that keep money at home in their own cabinet and wherever it is. And it's not necessarily illegal, but the reason why we're talking about this is because there's actually a charge in existence for keeping money of any amount that is suspected to be either stolen or unlawfully obtained.
And when might these charges come around, Q? So what would sort of need to have happened first, or what would be, what are the police or the prosecution looking to prove, I suppose?
Well, there are varying circumstances where an unlawful possession charge can crop up. So in a very traditional sense, very common, I wouldn't say traditional, very common for unlawful possession of money to come in tandem with drug charges. It comes in with no surprise because of the drug issue, the rampant drug issue in Western Australia. But usually the possession of money, an illegal amount, a stolen money or unlawfully obtained money usually comes in with drug charges. That's because drug in itself is an illegal enterprise. So whether you're selling drugs or you're getting profit from drugs, the money coming out of it is an illegal enterprise. So if you have money that is found in tandem during a search warrant or a seizure of certain assets, they find money, and that usually is a single charge in itself of possession of unlawfully obtained property. The money itself will be a criminal charge. Now, when drugs come into play, so for example, if you're charged with a drug charge and unlawful possession of money is also a second charge. It's very regular. It's normal for a separate legislation called the Criminal Property Confiscation Act to be triggered. That is obviously if the offense is severe enough, and if the offense is an indictable offense or an idle way offense. then usually the CPCA, Criminal Property Confiscation Act, will kick in.
And before you go any further there, Q, just elaborate if you can on what a summary and what either way offences are, just for those listening so that they understand where you're going with that.
Yes, so there are two or three kinds of charges out there. There's a summary charge. That means simple offense in a very colloquial way of putting it, simple offense. And then there's also the indictable charges, which are the more serious charges. Indictable charges can't be dealt with in trial in the magistrate's court. They have to be dealt with in the district court and above. An either way charge is a charge that goes either in the magistrate's court or the district court, but that would depend on what I would call the Section 5 factors. Now, possession of unlawfully obtained property was in the past a simple offense. So that means all the charges for unlawful possession charges are to be dealt with or were to be dealt with in the magistrate's court. But in the recent time, there is an enactment or an amendment of the law where this specific charge is now an either way charge. The reason why they've done so is because there's a vast majority of drug cases where an accused is charged with possession of a marketable quantity of drug or a serious amount of drugs, and they are found with, say, $500,000 of cash on them. Last time, the charges had to be split. One had to be dealt with in the district court or higher, and the other one had to be dealt with in the magistrate's court. The other being the cash charge, the money charge, had to be dealt with in the magistrate's court because the previous legislation didn't allow the charge to be dealt with at the same time the drug charges. So in the recent years, they have amended the law and they made it an either way charge, obviously subject to what we call Section 5 factors in the criminal code. Subject to all these other various regulations and statute being satisfied that the charge to be dealt with in the district court, the possession charges can now be dealt with together.
And is there, in relation to that as well, Q, is there a threshold, I suppose, for the monetary value, or is it just sort of looked at in conjunction with the other offences as to whether it goes into the indictable category or whether it falls into summary? Is there some sort of limit?
Yes.
Or is it the seriousness in nature maybe of the entire offending?
So that is something I've argued very recently in court. That comes down to what I've just said earlier, a Section 5 of the criminal code issue. So the prosecution and the defense would be arguing as to what factors would result into the matter being dealt with in the district court or the magistrate court. That includes obviously the amount. So if you have $200,000, $300,000, $400,000 worth of cash at home, they can't be dealt with in both courts. The magistrate's court, they have to be dealt with in the district court because the value is so high that now goes up to the district court. Apart from that, obviously, they also consider whether it's a compounding charge with other drug charges or is it a standalone charge by itself.
Okay.
If it's a standalone charge, then things are a bit different. But if you're charged with, say, other drug charges, then unfortunately the matter goes together with the drug charge to the district court if it's a serious drug charge. And if it's a serious drug charge, it does not preclude the issue of having your properties seized under the Criminal Property Confiscation Act. Now that's a separate issue. We'll talk about it another time. But that's a completely different issue that you have to deal with. It's a civil issue between the accused and the state as compared to this money charge.
So that won't be heard all together with the other charges?
No. I've digressed, yeah.
Yeah, okay. Now, in respect to, back to the unlawful possession of money, now what are the prosecution looking to prove? What is their burden of proof and what are they looking to prove to be able to draw the inference that money has, been illegally obtained? What are they looking at?
So, for the purpose of this podcast, we're talking about just unlawful possession of money in itself, this money charge as a standalone. So, for example, the police go to your house and raided your house because of other issues. They found, say, 70 grand worth of money in there. They go, all right, I'm going to charge you for this money because it appears that, you can't substantiate it. It's all well and well to say that if you're, for example, a businessman, a wealthy businessman, and you keep, say, 100 grand at home, the police are more than likely to just leave it alone and not charge you. But it's always a case-by-case basis. So to say that keeping money at home instead of putting it in the bank is wrong, I would say so. I mean, we can't really assert that. But the problem is, if you have money at home of that much quantity, the first question is, what gave rise to the police coming to your house or search your car? To search your car, did they smell cannabis when you wound down the window, or did they intercept your phone and find that there was a deal going on and they find money in your house? Usually money charges, although they stand alone sometimes usually they come in with other issues. They start with something else. There has always been another trigger.
Yeah.
So where there is another trigger, irrespective of the situation, the police needs to prove, as a criminal offense, as it is a criminal offense, they have to prove beyond reasonable doubt. Now, the burden rests upon the prosecution to prove every element of this specific charge beyond reasonable doubt. They have the burden of satisfying the court on the balance of probabilities that they have no grounds for suspecting that any item was stolen or unlawfully obtained. Well, they have to satisfy the court that. The prosecution, however, has the burden of proving beyond reasonable doubt that the accused was in possession. Number 2, of a thing capable of being stolen. Number 3, that it's reasonably suspected, or the police reasonably suspected, that the item can be stolen or unlawfully obtained. Now, what is unlawfully obtained? What is the reasonable suspicion behind it? The prosecution needs to satisfy the court and to allow the court to reach an objective conclusion from the evidence led as to whether or not the goods or the money might reasonably be suspected to be stolen or unlawfully obtained. That's in the case of Ryan and Dimitrov. In the case of Ryan and Dimitrovsky, that is also the case of McLennan and Campbell. So they bear the burden and the onus of proving all of these things. Now, if the court can be satisfied on the evidence, on the face of the evidence brought forth by the prosecution, that there is one single reasonable suspicion open on the evidence that the money in question might have been stolen or unlawfully obtained, then obviously the charge has been proven. So that is what they need to prove. That's the element and the proof. Now, the question is whether or not keeping money at home would automatically, trigger these charges. The answer is no. It does not automatically trigger it. It does not normally just come around like that. It obviously comes around because of other issues.
Other circumstances.
Yes, that's correct.
Okay. So now, is there anything further, Q, that you want to add on that topic, or do you think you've canvassed that effectively for everyone listening?
Yes. So that means what I'm trying to get at is the charge, keeping money at home does not mean that you would, automatically be charged for this. It doesn't work that way. They always come about in a different manner. There are trigger events.
Yeah.
But I guess the take-home message is something like this does exist.
Yeah.
They can exist for money, but the property need not be money. They can be other things as well. So they can even be a car, possession of unlawfully obtained property being a car. So, that's another issue, obviously. But that is, for example, if you have a car that's unregistered and a mate gave it to you, and the mate is in prison, for example, and you have that car, and the car has been on the police's VKI, being tagged as stolen, then you have an issue because they would charge you and say, look, it's unlawfully obtained. What I'm trying to get at is the same approach in which they deal with the car they would also use the same approach for money.
Mhm.
It obviously comes down to the investigative power of the police.
Yeah, and what they can provide to be able to draw the two together, or to link it to the behaviour, I suppose.
That's correct.
Beautiful. Okay, well, as we always say at the end of our podcasts, if you do have any further questions or you are being charged with this offence or something similar, we would like you to call our office and make touch with Q, and that way he can go through things a little bit further with you.
Yes.
But for the purposes of today, I think we're done. So until next time, thank you.
Thank you.